हेलो एवरीवन, इस वीडियो में मैं आप लोगों के साथ एडमिनिस्ट्रेटिव लॉ के MCQs डिस्कस करूंगी जो आपको अपकमिंग एग्जामिनेशन में फॉर श्योर हेल्प करेगा. सो लेट्स स्टार्ट. फर्स्ट क्वेश्चन इज अकॉर्डिंग टू द डेफिनेशन ऑफ एडमिनिस्ट्रेटिव लॉ can be defined as a law relating to administration. So this definition is given by whom? That administrative law can be defined as a law relating to administration, and the correct answer is Sir Ivan Jennings. Next question is, when the functions of the legislature are entrusted to organs other than the legislature by the legislature itself, then legislation made by such organ is called delegated legislation. Next question, administrative law is a branch of public law. According to A.V. Dicey, which of the following is not the meaning of rule of law? And answer is king can do no wrong. This is not the meaning of rule of law, and the other third options are correct. That rule of law means supremacy of law, equality before the law, and predominance of legal spirit. This is very important question. Next question is, delegatus non protest delegere means, what is the meaning of this maxim? And the answer is no delegated power can be further delegated. Next question is, personal bias means, and answer is when the person sits as a judge and one of the parties is his relative. That is called personal bias. Next question, Montesquieu propounded the theory of separation of power based on the model of, answer is UK. So the propounder of separation of theory was Montesquieu, and it was based on the model of UK. Next question is, A.K. Karepak versus Union of India is a landmark judgment in relation to what? This is related to the bias. Next question is, speaking orders are the orders which are issued by, answer is administrative authorities. Next question, under Right to Information Act, information is furnished on the payment of fees as may be prescribed. So that is not given free, but there is some nominal fees to be paid. Next question, which of these is not a public corporation? Answer is NGO for the disabled person not fall in public corporation, while other three, Oil and Natural Gas Commission, Reserve Bank of India, Damodar Valley Corporation, these will fall in the definition of public corporation. Next question is, the chairman or any member of the Public Service Commission in India can be removed. Answer is only by the president. Next question is, as per the emerging trend of global governance, the administrative authorities are exercising its power in, answer is maintaining law and order only, performing quasi-legislative functions, performing quasi-judicial functions. So all of the three are important. Next question is, fourth branch of the government is, and the correct answer here will be the administration as per the development of administrative law. So this will be the correct answer. Next question is, administrative law was evolved by judiciary. Next question, who defined administrative law as the law which determines the end and modes to which the sovereign power shall be exercised? The sovereign power shall be exercised either directly by the monarch or directly by the subordinate political superiors to whom portion of those are delegated or committed in trust. And this is the definition given by Austin. Next question, systematic and scientific framework was given to the doctrine of separation of power by Montesquieu. Next question, in Indian context, the doctrine of separation of power is, answer is not followed strictly. Next question is, who said delegated legislation is that which proceed from any authority other than the sovereign power, and therefore it depends from its is dependent from its continued existence and validity on some superior or supreme authority? And the answer is summoned. Next question, the power of authority which makes subordinate legislation is, answer is limited to statute which conferred the power. Next question is, the statute enacted by the legislature conferring the legislative power upon the executive is known as, answer will be none of the above. Next question is, which of the following is not the reason for the growth of delegated legislation? Answer is incompetency of the parliament. So this is not the reason for the growth of delegated legislation, while others, to reduce the pressure upon the parliament, technical know-how of the subject matter, and to cope up with the emergent situation. These three are the reasons for the growth of delegated legislation. Next question is, what is true about conditional legislation? Answer is, there is no element of delegation in it. So conditional legislation is not a delegated legislation actually. Next question, the first case decided post independence by the Honorable Supreme Court on delegated legislation was Re-Delhi Laws Act. Next question, which case is known as the Bible case for delegated legislation? And the answer is same, Re-Delhi Laws Act case. Next question, the test which is used in determining the constitutionality of the delegated legislation is abdication test. Next question is, which of the following does not embraces the control mechanism of delegated legislation? Answer is social. While other controls are there, parliamentary control, judicial control and administrative control are there on delegated legislation. Next question, where Parliament exercise its direct control in respect of delegated legislation, which of the following is mandatory in nature? Answer is affirmative laying. Next question, which of the following is not the meaning of rule of law according to the A.V. Dicey? So wide discretionary power is not a meaning, while supremacy of law, equality before law and predominance of legal spirit is the meaning of rule of law. Next question, A.V. Dicey criticized which legal system? Answer is French legal system. Next question is, dash is considered to be the doctrinal barrier for the development of administrative law in USA, and it was the separation of power which was considered as the barrier for the development of administrative law in USA. Next question is, the doctrine of separation of power was systematically propounded by Montesquieu in his book The Spirit of Law. So the book name is also important here, The Spirit of Laws. Next question, which of the following is true out of these? And true is the legislative order has to be published. Next question, which of the following is not held to be quasi-judicial function? Answer is, a order of preventive detention is not considered quasi-judicial, while determination of citizenship, disciplinary proceedings against student, determination of disqualification of member of parliament are held to be quasi-judicial functions. Next question is, the principle that by exercising the power of modification the delegate cannot change the legislative policy was developed in the case of? Answer is Delhi Laws Act case. Next question, which of the following is true when a government contract which does not conform to the provision of Article 299 of the Indian Constitution? Answer is A, the contract is not enforceable in court against the parties. Next question, which of the following is the right definition of the phrase nemo judex in causa sua? And the answer is, no man shall be a judge in his own case. This is the right meaning. Next question is, which of the following is not a control on delegated legislation? Answer is D, doctrine of lifting the veil is not a control, while judicial control, legislative control and doctrine of ultra vires is also a control on delegated legislation. Next question, which of the following is not a ground of procedural ultra vires? Answer is subdelegation is not a ground of procedural ultra vires, while non-publication of rules, no consultation are the ground of procedural ultra vires. Next question, which of the following is not the ground for substantive ultra vires? Answer is where mandatory consultation process is not complied with, that will not be a ground for substantive ultra vires, while where the Parent Act is unconstitutional, Parent Act delegates essential legislative function, or when the delegated legislation is itself arbitrary, then these three will be the ground for substantive ultra vires. Next question, principles of natural justice are not applicable against which of the following actions? Answer is rule making action. So principles of natural justice are not applicable in case of rule making action, while it will apply in case of administrative action, quasi judicial actions and judicial process. Next question is, principle of natural justice are applicable even when the statute is silent. They do not supplant law of the land but supplement it. This was held in which case? And answer is A.K. Karyapak versus Union of India. Next question is, which of the following is not a type of bias? And answer is none of the above. So these three are the types of bias: pecuniary bias, personal bias, or judicial obstinacy. So these three are the bias. Next question, which of the following is not an essential component of the doctrine of odi ultram partem? And answer is oral hearing. Oral hearing is not an essential component. So there may be oral hearing or may not be, but right of notice and reasons decision are the essential component. So these were some important MCQs of administrative law. I hope this video will help you, and if you find this video helpful, then subscribe this channel for more such relevant videos updates. Thanks for watching.